morning.
May I please, your Lord? I thought item number 18, my Lord, please.
Yes. Item 18. Yes. Mr.
AHMR Chaudhary.
A.H.M.R. Chaudhary for the petitioner. Anyone for the respondent? Government? M.S. Burman? Huh?
I also.
M.S. Burman, Government Counsel, and A. Bhattacharya, Standing Counsel, Revenue. Mr. So-and-so, Learned Counsel for the petitioner submits that he has received instructions from the petitioner not to press the instant writ petition and accordingly seeks withdrawal of the same. In view of the aforesaid endorsement, the writ petition stands dismissed on being withdrawn.
I beg to mention item number 9, madam.
Item number
9, madam.
9.
Sir, review matter regarding FT matter, madam. So, DB matter, madam. Perhaps
Wrongly
listed.
list before appropriate bench.
Yes. Item number 23. I have filed item number 23. My Lord. I have filed an affidavit in opposition. I will be allowed to bring it on the record.
All right, Mr. Borwa.
May I please? I just mention item number 15, my lord. Item number 15.
15.
Yes.
Yes.
On behalf of SC Business.
As prayed for by Mr. S.C. Biswas, Learned Counsel, appearing for the writ petitioner, relist after 3 weeks on a date to be fixed by the registry.
Oblation.
May it please, my lord. Lordship, I beg to mention item number 14 of today's list. I am appearing on behalf of Mr. N. Borwa, the counsel for the IOCL. Lordship, he is out of station and we need to file an affidavit in this matter.
I am appearing for the petitioner, my lord.
Yes, you have any objection, Mr.
Objection only, my lord. Can it be fixed in the
All
first
right.
week of November?
All right. Heard Mr. S. Bhattacharya, Learned Counsel, appearing for the petitioner. Also heard MS.
MS P. Datta on behalf
P.
of
Datta, na?
Yes.
Learned Counsel, appearing on behalf of respondent IOC, who submits that the standing counsel, Mr.
N.K. Borwa.
N.K. N.K. Barwa, who is handling the brief on behalf of the respondent IOC, is out of station and accordingly seeks a short accommodation. Prayer is not opposed. Relist on such and when do you want, Mr. Bhattacharya?
I shall be out of station in the middle week of October, my lord. May I pray that it may be fixed on any date, first week of November, my lord.
Relist on such and such date. Interim, if any, shall continue till the next date of listing.
My lord, one more thing. Interim order was passed, my lord.
I
That may continue.
just said
Obliged, my lord.
yes. All right.
Obliged.
Next.
May I please, your Lord? My Lord, item number 13. I filed a withdrawal petition, your Lordship. The grievances of the petitioner is made already.
This is the IA that is the IA is for withdrawal.
Yes, yes.
Then in the IA, but it is the IA is in a contempt.
Yes, your Lordship. I have filed a withdrawal. It is.
Are you in a hurry? Otherwise, we will call this item 13 as the first item in the order. It is in the orders. All right, we'll take it up immediately after the mention. Just wait. Yes, next.
I beg to mention item number 11 of the daily list. The advocate for the petitioner, Miss M. Dev, she has sudden illness.
All right. As prayed for on behalf of MS M. Dev on grounds of medical illness, relist after 2 weeks on a date to be fixed by the registry. Yes, next.
Item number 13.
The IA is for withdrawal.
Yes, your Lord. Page number, the grievances is made, your Lord, resolved already.
But can a withdrawal petition be filed in a contempt proceedings? Once you bring the alleged contempt before the non-compliance before this court, it will be between the court and the contemptor. If it is complied, the contempt can be closed.
I beg to inform your Lordship through this IA.
All right. So, some contempt announcement. Give me the main contempt. You pass this order in the contempt, huh? Heard, Mr. A. Nigeri, Learned Counsel, appearing for the petitioner. Stop. Anyone? Any contemptors? Anyone for the contemptors had appeared? No, not yet. None appears for the contemptors on call. Mr. So-and-so, Learned Counsel for the petitioner, submits that during the pendency of the instant contempt petition, the the respondent authorities by issuing an order dated 26/5/2025 has already complied with the judgment and order dated 6/8/2024 passed by this court in WPC number 1248/2024. Stop. It appears that the aforesaid letter stating the compliance of the judgment in order dated so and so is also brought on record by filing an interlocutory application I 3185 of 2025 in the present contempt case. Peruse the aforesaid judgment in order as well as the letter dated so and so enclosed as annexure so and so to the interlocutory application. Nothing survives for adjudication. Contempt stands closed. I, Beleke Didima, accordingly stands disposed of.
Highly obliged.
For motion, item number 1.
May I please, Your Lordship? This payment, this matter relating to non-payment of ex gratia relief.
Notice.
Notice may be.
Minute, I raised the preliminary objection regarding the maintenance.
All right, we will see then
Yes.
later on.
Yes.
Let notice go first. Heard notice, Mr. A. Bhattacharya for
That's
Yes.
one number 1.
1 and MS Barman
4, 5, 6, 7.
4, 5, 6, 7. What about 2 and 3? Finance
3,
Se-
3
se-
to 5, sorry, ma'am.
3 to 5. 3 to 5 and 6 GRPS
Comment.
We can take it.
Ms. Barman 6.
Comment.
All right, 6 also Barman. And yes, Mr. Parashar, you are for 7. Mr. Parashar 7. Still, number 2, Commissioner Secretary Finance, yes, MS H. Barwa on behalf of P. Nayak for 2. 3 weeks.
Lordship, my name is not reflected in the cause list.
Let the name of Mr.
Ardeka.
Ardeka be reflected in the cause list
Obliged.
by the registry. Huh? Yes.
Item 2. Wait, please, Your Lordship.
It's the narrative and legs in court 1. Lordship may take up the matter after some time.
Supplementary list, item number 16.
Well, the petitioner has been issued with a notice, Malak.
Yes,
Yeah,
Mr. Kalita.
Petitioner has been issued with a notice, Malak, eviction notice, Malak.
Hmm.
You will find that page 20, annexure 4, Malak. Under the provision of public premises, the unauthorized occupancy Act 1971. Malak, petitioners forefather, Malak, living in that area, Malak, Lordship knows that Landing town or almost all the lands are Malak, the railway land, Malak. Petitioners are occupying, forefathers occupied that land prior to 60 years ago, Malak. They are paying municipal tax, the electricity connection has been done, Malak. So, Malak, immediately, Malak, suddenly this notice has been issued, Malak, without any Malak, scheme of rehabilitation and resettlement. Malak. So, Malak,
Where is the notice?
Malak, page 20, Malak.
Page?
Page 20, Malak, annexure 4.
Yes. Railway land.
Yes, Malak. Without any Malak, bona fide reason, Malak, what is the, whether there is any project, Malak, nothing has been disclosed.
Yes, Mr. Chaudhary.
Your Lordship will see, this eviction notice has been issued subsequent to a show cause notice issued under section 4.
Where is that?
That
That's
is
what
on
I was
page
trying to
19.
find out.
Page 19.
So that was the precise question in the mind of this court. So this was preceded by a show cause notice.
Yes, it was preceded by a show cause notice. And in fact, Lordship, a writ petition would not lie because under section 7 of the Public Premises Act, against an order passed under section
1
5,
second, this show cause notice was dated when?
So first notice was, my lord, at 13/6. It was received on 18/6.
In the month of June.
Yes, my lord. And
Mr. Kalita only notice, I'm sorry. I cannot give you anything more.
And I feel like-
Immediately on the opening date, you file your whatever is there.
Lordship,
Whether some maintainable, not maintainable, this court will look into that after the returns are filed.
Lordship,
my lord, may I put that till then, my lord?
Mr. Kalita,
Till then.
sorry, you should have come earlier when you got the show cause notice.
After show
Heard
cause-
Mr.
After so cause notice, my lord, one
N.K.
hearing was
Kalita,
conducted.
learned counsel appearing for the petitioner. Stop. Also heard Mr. R.K.D. Chaudhary, na?
yes, Lordship.
Learned
DSGI for 1 and 2.
DSGI for respondent numbers
1 and 2.
1 and 2. And Mr. A. Bhattacharya, learned standing counsel revenue 3. And what about 4? Lumding Municipal Board, that is by registered?
No, my lord,
Municipal
Government-
board
Yes,
is
government
notice.
can notice.
I think no, municipal board government cannot take.
No.
And Pisot Dimbar Hetu. By way of this writ petition under Article 226 of the Constitution of India, the petitioner is assailing the impugned eviction notice dated 9/9/2025 issued by the respondent number 2, whereby the stop, huh? Issue notice returnable on reopening date on such and such date. Mr. So-and-so except for so-and-so's, Bhattacharya for so-and-so and register extra copies within today. Because I'm fixing it on, so today within the course of the day and registered post by AD, respondent number 4. Steps 2 days. Tomorrow is the opening. Tomorrow is an opening Saturday.
today itself.
You can take it
Yes, sir.
anyway 2 days quit with Yabaru within 2 days. Interim to be considered on the next date.
My lord, one hearing was also conducted, my lord.
All right, you bring it on that date. Yes,
Can it be on 14th, right?
14th.
14th, right? I
Okay.
get a date to file by.
All right, 14th.
Item 17.
You see, Mr. Chaudhary, I have kept the interim on that date. So
Yes, yes.
keep that in mind and also ensure that whatever you want to file is
Yes,
filed.
yes, I will.
I am not going to,
I'll do that.
I've given you the opportunity. Yes. Yes, Mr. Das.
These are the now legacy. Met resolution. My lord, this petition, my lord, your lordship will kindly see, we had a garden waiting tea state. Now in this garden, about 2,000 odd bighas of land we had, but it was acquired by the government for putting up a Brahmaputra gas breaker project. Accordingly, they have put the gas breaker project and about 381 bighas of land, it was acquired by the government for the purpose of this project. And they acquired, but the compensation amount, they could not pay at that relevant point of time. Now, my lord, we have taken loan from the bank for this entire garden. Different loans was given, but that loan somehow the garden was not properly running in the state. So ultimately, the amount overdue was there. Now we came up before this court about 18 crores, pay the principal amount, some interest were there. But we came to the court and we said that, sir, that some time should be given to us because the compensation amount has not been paid. Court considered and court said, okay, we are giving you time, some time, which is your lordship will kindly see at page 27. Otherwise, entire amount will become an NPA.
Who is
So-
there for the other side?
It is, my lord, the bank, my lord, Indian Overseas Bank.
Indian Overseas Bank.
There is sending.
Yes,
us a-
page.
Page 27, my lord, 27. This is the order that was passed by the court. Now, my lord will kindly see at page 29. In the aforesaid facts, as stated by learned competent, this court is of the view interim till a respondent bank is served and appears before this court, respondent may maintain status quo as regard the loan account of petitioner. Upon the respondent bank entering appearing, this court would consider as to what appropriate interim order is required to be passed in the instant writ petition. In order to expedite the matter, as an interim restraint order has been passed merely on a submission, this court deems the approved notice be served upon so and so. Accordingly, petitioner is to take steps, so and so does the submitted by so and so and so and so. My lord, because it will become NPA, again there will be a problem. We said that let us get the amount and we will repay the amount. Accordingly, we paid and we paid the amount to the bank. Now, what has happened, my lord? Once it is paid, because there are different loans, it has to be restructured again. So accordingly, we made a request, please restructure the entire loan. Accordingly, it was done at page 31. Kindly see at page 31. Credit sanction advice, kindly see at page 31. We paid, page 31 is the credit sanction advice, they restructured. Now restructuring from page 31 to 36. Different, my lord, will
So
kindly
this,
see.
they have restructured the loan.
Yes, entire loan. Now, if your lordship looks into annexure 4, page 37, after that, what has happened? They have given a notice by the bank. We were paying to them.
As per the
Yes,
restructured
restructuring,
loan.
we paid. But there was an overdue. At page 37, they issued a notice by the bank on 5/8/2025. Kindly see, my lord. 5/8. If your lordship turn to page 38, this is 71 lakhs 0.03.
Yes.
Overdue. That's an overdue. Now kindly see third.
Overdue means you paid more.
On a basis of cash credit facilities, we were running the garden. So on the basis that particular we have to, it become an overdue. So now see kindly 38. In this connection, on the last 3 lines, please make a note that if you fail to repay the overdue, so and so your account will be classified as NPA as per RPI guidelines, and same situation in 2017 which are protected. Now we requested the bank. Now thereafter we paid to the bank, my lord. 26 lakhs we paid. Out of the 71.03, we paid 26 lakhs. So now it came down to 58 lakhs an odd amount. Overdue.
58 of?
Out of 71 lakhs.
So 58 odd is due.
Yes, odd is due. 58.45. Now we request that the bank kindly see at page 40.
Yes.
If you see at page 41, now third paragraph.
Yes.
Further, we would like to state that a grant of permission, issuance of no certificate, sale of
Page 40.
40. It starts from 40.
Third
No,
paragraph. Is the-
Your lordship, what we made a proposal to the bank. They look here, this is the amount we are going to pay.
So page 40 is your
request.
request.
What was the request? I'll just tell your lordship. We went to the bank. We said we are ready to pay the amount. Now they said, what is the alternative? You tell us. I said that we have a land which has been mortgaged. Mortgage, that's not a T-state land. This is a personal land. So you release that land. 35 bighas you release it. We'll file some customer and accordingly we'll pay. The bank agreed to it. Bank said, okay, we have agreed to it, but with certain condition we have agreed. What is that condition? Kindly see, my lord, at page 42. 10/9/2025.
Now,
This is C at page 42.
Yes.
Please mark the date 10/9/2025. On
Yes.
top. Now, subject NOC for release of some portion of land, 35 bighas 3 cutters with reference to so and so from request letter dated so and so out of. Now see, my lord, the condition. Branch will release the properties only after finalization of the sale transaction. Sale proceed to be credited to the CC account and all the overdue account to be regularized immediately. Details of the land to be released as per your request. So this is what they said. Condition, there are 2 conditions. This whatever is that, we'll do it. Once you finalize it, you have to bring the customers with whom and entire amount has to be deposited in the CC account. Now, if your lordship looks at page 44, they renewed the loan account. they renewed the loan account. On this proposal, they renewed, which kindly 44 to 76, your lordship kindly see, because different accounts are there. So from 44 to 76, these are all they renewed the loan account. Absolutely, there was no problem. They renewed. Now the problem, why I am before this court? We found customers. Now the customer is the problem is that he said you have to wait till November. November, you have to wait and we will we'll buy it and we'll pay the amount. We went to the bank and we went to the bank. We said, this is a proposal, you please give us time. Till
Give
November.
us time.
Till November. This November, and we will all finalize. But that they are not agreeing to it. That's the whole problem we have come. So very limited prayer, my lord. There is no law as such in this case. There is no law. Only limited prayer. Please give us time till November. And we will, my lord, your lordship can observe that till November only will give us time and we'll pay the entire amount. There is absolutely no problem.
No, but I cannot dispose of this writ
No,
petition.
there is no question of disposal. My lord, my prayer, limited prayer before lordship is.
What is your main prayer in this writ?
Yes. My lord, not to classify as an NPA. There will be absolutely a chaotic. Your lordship can maintain a status quo order. In the meantime, we'll take a dusty service. On the reopening, let the bank come.
I think that would be
Status quo, my lord. Let us status quo,
Alright.
man.
heard Mr. D. Das, Learned Senior Counsel, assisted by Mr. S. Deka, Learned Counsel for the petitioner. Stop. By way of this petition under Article 226 of the Constitution of India, the petitioner is seeking direction to the respondent number 1 bank not to classify the loan accounts of the petitioner as NPA and not to take any stringent action against the petitioners at least for 2 months, i.e. till 30/11/2025. Where do I get the facts?
Synopsis, we have given, I think synopsis, my lord, we have given the facts.
The brief
Your
fact
lordship-
of the case is that
Second
in
page.
the year
synopsis is-
2006, the government of Assam acquired a substantial portion of the tea estate of the petitioner, and thereafter compensation was awarded. However, the same being not satisfied, LA appeals were filed before this court, which are still stated to be
Yeah.
pending. After acquisition of the garden, as the productivity of the these parts are, I think, not
Your
required.
lordship didn't have to do all this. Second page is important. Second. Then after restructuring, that they pay, certain amount was paid and it was restructured.
It is the specific case of the petitioner that after acquisition of the garden, as the productivity of the garden decreased, the respondent number 1 sought to declare the loan accounts of the petitioner as NPA. However, upon approaching this court by way of WPC,
Page 27.
I have
1963.
by WPC 1963/2017, this court directed the respondent bank by order dated 30/3/2017 to maintain status quo in respect of the loan accounts of the petitioner.
Yes.
Stop. It is the further case of the petitioner that even after filing of execution case, as the authority failed to make payment of the compensation amount to the petitioner and the PF authority issued final notice upon the petitioner, the petitioner preferred another writ petition and ultimately, in view of different orders passed in the said writ petition, the authority paid the compensation amount and consequently petitioner cleared the PF dues and the loan overdue of the respondent bank. It is the further specific case of the petitioner that as per the policy of the RBI, though the petitioner was entitled for restructure, correct?
Yeah.
The restructure of their loan account, the bank authority did not consider the same. Hence, the petitioner, you again filed a writ
Yes,
petition.
yes.
Hence, the petitioner approached this court once again by WPC.
6775/2019.
Once, where do I get that reference?
Page 11 law, paragraph number 15.
Page 11.
Para 15, page 11.
Page 11.
Page 11,
Page
para
11, para
15.
50.
By WPC 6775 of 2019. What happened in that?
In dependency of the they said that they are going to restructure it, restructure the loan. Kindly see paragraph, the pendency of so and so.
Wherein during the pendency of the said writ petition, the respondent number 1 bank by letter dated 10/10/19 intimated the petitioner that they are going to restructure the loan accounts of the petitioner, and for that purpose, they have engaged one ITCOT Consultancy Service Limited. Stop.
Lordship direct can go to page 31. They restructured this one.
Thereafter,
At
they
page 31.
restructured the said loan account of the petitioner on
29/12/2020.
29
12/2020.
12/2020. Stop. This is at page 31, right?
31. Kindly see page 31.
Yes. After that, page 37.
Yes. After that, my lord, page 37. Then we were paying regularly.
It is the further case of the petitioner that accordingly the petitioner was paying regularly in terms of the restructure
Yes.
as done by the respondent bank.
Yes.
However, due to some certain overdue,
Yes, at page 37.
comma, the respondent bank by letter dated 5/8/2025
Page 38.
directed the respondent petitioner to repay the said overdue of rupees 71.03 lakhs, failure of which the account shall be classified as NPA.
Yes.
Correct? This,
Yes,
this
correct,
is what
correct.
it says, right?
Yes, yes.
Stop.
Then thereafter.
However, it is the further case of the petitioner that though out of the 71.03 lakhs overdue, an amount of rupees 26 lakhs odd was
26 lakh
paid.
15,000.
26?
26 lakh 15,000.
26.15 lakhs, right?
Oh, 26 point.
Just please ask your junior to just put these figures and give it in to the court master. 26.15 lakhs was paid. However, an amount of rupees 58.45 due, 45 was still remaining due.
Which your lordship will find at para 20. Para 20.
Situated thus, now thereafter they had given you a note. This is the situation you had
This
come,
was
no?
situation, then we made a request.
Proposal.
Thereafter, the petitioner on 25/8/2025 made a request to the respondent bank to,
Release.
this is at page 41, no?
Yes,
yes.
41,
Which is the
third
relevant
paragraph.
paragraph?
third paragraph.
Further, no, we would like to request you
Yes.
to grant permission to the stroke issue no objection certificate
For sale of land.
for sale of one of the some portion of the garden land which was which is mortgaged with the respondent bank.
NOC issued at.
Thereafter, the respondent bank by letter dated 10/9/2025, which is enclosed as Annexure 6 to
Yes.
the writ petition, issued the NOC for release of some portion of land, I 35 bighas, 3 kathas, 14 lectures out of total mortgage land, out of total mortgage land, I 1637 bighas, 4 kathas, 16 lectures.
Yes,
Okay?
yes.
With the condition that the respondent bank branch will release the properties only after finalization of the sale transaction. 1, 2, 3 করে দিবা, huh? Number 2, sales proceed to be credited to CC account and all the overdue accounts to be regularized immediately. Number 3, details of land to be released as per the request of the petitioner. Mr. D. Das, yes, what was, now tell me that
Now then
particular.
after why, see page 15, paragraph 25. Page 15, paragraph 25.
Now I'll make it short, but I
Yes.
just want to say
no.
what time you want and.
Yes, this is.
Page 15.
15, paragraph 25, 26. Your lordship, it's everything is here. 25 and 26. See paragraph 25.
Mr. D. Das, Leonard Senior Counsel, submits that after several rounds of discussion and negotiation, the petitioner was able to find 2 prospective buyers who agreed to purchase the aforesaid land. However, the aforesaid purchaser intimated the petitioner that they will be able to pay the sale consideration amount within the 3rd week of November 2025.
Yes.
He further submits that the petitioner has verbally intimated the same to the respondent number 2 bank. However, that they will be able to make payment of the overdue amount to the respondent number 1 bank only in 3rd week of November 2025. He further submits that the respondent number 2 threatened the petitioner that if the petitioner does not pay the overdue amount within 28/9/2025, the loan accounts will be declared as NPA.
Yes, that's the case.
He further submits that it is on this premise only that the present petition
Yes.
was necessitated to be filed only for enabling the time to the petitioner to complete the sale transaction as per the condition imposed by the respondent bank by the NOC dated 10/9/2025. Third, issue notice, returnable 3-4 weeks, and steps within 3 days within a week from today. Upon hearing the petitioner for interim and perusal of the documents, it appears that this court is of the view that in the interim, till the respondent bank is served and appears before this court, the respondent may maintain status quo as regards the loan account.
Yes.
That's all. Loan account of the petitioner.
Yeah,
Stop.
accounts.
Loan accounts of the petitioner. Relist on such and such date. Yes, give a date.
Yes, date.
I think that should be sufficient.
Yes. Date. Some date will be fixed.
Yes, give a date.
Third. Date will.
Till then, Mr. Das, should I add that by then you can give the update status of your negotiation, because you see November we are going. So you may expedite by then.
Yes.
Should I indicate? All right, I'm leaving it, but you are at liberty to anyway, you have that liberty
Yes.
to bring on
Yes,
if
yes.
something materializes.
We'll bring it by an additional.
Correct. If anything materializes by
We'll
then.
bring it by addition. Deeply authorized.
Item 19.
The petitioner was elected as a member of a town panchayat. What you'll find it page number 19.
Page number
19.
19.
19. See this real number 3 minor. This is the certificate issued by the authorized officer of select. He has been elected. He secured 414 votes, my lord.
He was appointed as what?
No, he contested the Panchayat election and she was selected and getting highest vote, my lord. What you will see in CL number 3, securing 414 votes is the highest and she has been selected.
Post of member Gaon Panchayat.
Now, Panchayat.
Yes.
Thereafter, my lord, as per the procedure, my lord, under Rule 46, they need to make a first meeting. Now, you will find to page number 21. He was given the letter for attending the first meeting, my lord. That is to be held on 11/7/2025 at 9:30 AM.
Just one sec. AC to take forever. Speed to comments. Yes.
Letter dated, my lord, 7/7/2020, by the Secretary of the Gaon Panchayat, that you are required to attend the first meeting on 11/7/2020 at 9:30 AM.
Yes.
So in that first meeting, there will be a vote as well as selection of president and secretary. My lord. So she appeared in before that particular venue, my lord, for attending the meeting, my lord. In that particular meeting, my lord, it is the duty of the deputy commissioner to authorize one officer of his choice, my lord, to supervise the entire meeting, my lord. He was, my lord, lordship will find in page number 23, one Zakir Hussain. He is an assistant engineer of the assistant executive.
You are now what is your
What
grievance,
had
Mr.
happened
Bora?
on that particular day in a meeting, when she was there in the meeting to take the oath in a meeting, she was not allowed. She was physically pushed out of the
She was not allowed to take the oath.
oath, as well as not to that oath means that he couldn't participate in the selection of the president and president and the vice president, madam. So he was physically pushed out of the room. So she didn't appear on that particular, and the minutes were prepared in page number 25, selecting the secretary and the president as secretary.
Hmm.
So what had happened, my lord, after that, this pushing out from that particular room, that thorough inquiry was, what is the reason behind it? Then it came, my lord, what had happened, my lord, the person in the election, who lost the election, after losing, his husband has lost an FIR. What you will find the FIR in page number 30. It is dated 27/6/2025.
So your grievance is because is that you have not been allowed to take the
Take oath.
oath for which you could not
Participate. Now,
participate.
day-to-day activity, I cannot, she could not participate, my lord. Now, my prayer is, my lord, in the interim that, but DC should make arrangement to take oath and participate in the day-to-day meeting.
What is this? The page 30 is the FIR. So it is based on this FIR you have been not allowed.
Because of this FIR, she has not been allowed. FIR is that, my lord, his education qualification is doubtful because while giving an RTI, he didn't get any information. The losing candidate husband has filed.
Yes,
After
Ms.
the election.
Burman.
This has to go, my lord.
Notice can go, but why cannot the why should the
Person concerned against whom that allegation authorized officer, he is made personally party as respondent number 6. my lord.
That's it. But DC,
Otherwise, it's a.
DC can make arrangement for taking oath, my lord.
But that is your main prayer, Mr. Bora.
No.
Your main prayer is also for taking oath. Your
Yes.
interim of prayer is also for taking oath.
That's the-
So practically granting any interim order at this stage will allow. So I can post it on the reopening day itself. You have your instructions. I'll issue notice, but I'll make it clear that if no instructions comes on that date,
Lordship, it's not
this
necessary
court
order.
is going ahead and giving the relief. Because this is not a matter to be kept pending. This
Lordship.
matter can be disposed of depending on the instructions that is going to come, Ms. Burman, on the
Right,
next date. All right, I'm going to
Only
clarify that.
Lord.
Mr. Bora, not
no date, my lord. Lord will post it on 15th, but
all
not
right,
13th.
no worries, Mr. Bora. That much accommodation this court will give you, Mr. Bora. Heard Mr. S. Bora, learned counsel appearing for the writ petitioner. Also heard MS M. Burman, learned government state
For
counsel
respondent
for
number
respondent number
3.
3. Anybody else?
Panchayat.
P. Thapa for respondent number 1, 4, and 5. A.B. Kayasta for respondent number 2. So all have been represented.
6, 7, 5, 8, and 4 number. 6, 7, and 8.
Can you take Dusty as well?
Typical man, Dusty man.
6, 7, and 5 by Dusty.
6, 7, and 8.
6, 7, and 8. Because then we don't know whether they'll appear anyway. You try 6, 7, 8 by registered post, baki any extra copies. By way of this writ petition under Article 226 of the Constitution of India, the petitioner is seeking direction to the respondents, more particularly the District Commissioner Nagaon, to allow the petitioner to take oath as member of 128 Tinsukia Gao Panchayat, which was allegedly denied to her on 11/7/2025 on the first meeting of the 128 Tinsukia Gao Panchayat by the respondents. Since the issue involved is denial of the petitioner from taking oath as member of the said Gao Panchayat, it is let instructions be let notice be issued, making it returnable on 15/10/2025, on which date the state councils shall positively place before this court as regards the reasons for not allowing the petitioner to take oath as member of so and so in terms of
Rule 46, my lord.
in terms of rule
46.
46
Within bracket 2
2 of the
of the Assam Panchayat within bracket Constitution Rule.
Assam
1995.
Panchayat Rules 1995.
Within the Assam Panchayat within bracket Constitution Rules 1995.
Okay, but in paragraph 3, you have not said that. Anyway, it will be Russo Saipala full to read. Stop. Relist accordingly.
Okay.
May I please your lordship? Lordship, Mr. ARVR is on lag in court number 5. Can you take up this matter after some time? Lordship?
What is the prayer? What is the prayer? What is the writ petition? What are you seeking?
Page 28, this is the prayer, my lord.
Yes, counsel, you don't even read the briefs. It's a motion matters. Matters are not adjourned mechanically.
No. Taking for
No, then why have you must be knowing what the prayer is. You are for the writ petitioner. Anyway, after some time.
May it please your lordship. My lord, your lordship.
Yes, Mr. Rai Chaudhary.
Trouble your lordship to page 23. Annex
No
of-
trouble, Mr. Rai Chaudhary. Yes,
Well, page
Page
23.
23.
That was this is a letter of intent issued by the Indian Oil Corporation Limited for a proposed Indian distributorship in the location of Silchar. Your lordship may look into right hand side. The date was 27/6/2011. And thereafter, my lord, there was a power of attorney issued by me to one of the person that I am legally Pal, whereas I have financial constraint, I issued a power of attorney that was dated 19/1/2012. Your lordship has got it, 19/1/2012, page 27,
Page.
27, 19/1/2012. There was a power of attorney given.
Yes.
My lord, this power of attorney was 19/1/2012, and that same was revoked, my lord, at page 33.
Yes.
That was revoked by me, and my lord,
You are the petitioner,
Petitioner.
Lipi Rani Paul.
my lord,
Yes, revoked.
revoked page 33.
Yes.
Then it was revoked, my lord, in the on 8/10/2012, page 40, your lordship will.
No, 33 is revoked.
Page revoked, and the last part of the revocation.
No, just 1 second. Give me the date of the revocation. 8.
Page 40, your lordship will find the date, 8/10/2012.
8.
10,
10.
2012.
12.
12. Then I entered into, my lord, agreement at page 42. That was in the right hand side. top, your lordship will find the date of agreement was 18/10/2012.
Page 42.
42, right hand side top, date of agreement was 18/10/2012.
1810
2012.
12.
I
Yeah.
entered. From 2012, I continued, my lord. Then, my lord, there was a change of a status of my farm. It became a partnership farm. So I informed the authority that I want to change myself into for reconstitution at page 63, your lordship will find.
2012, na?
12, my lord. Now it continued for next 12 years.
So this 1810 is that you continued as a partnership, as
No,
a
as a proprietor.
proprietor.
I was running that distributorship of Indian service.
Yes. And
Now
then
page 63, your lordship will find
60.
3, dated 21/11/23.
Yes.
My lord, for reconstitution of my distributorship from
Yes.
proprietorship to partnership.
Hmm.
This is the approval.
Yes.
21/11/23, this was the approval given, and the status of the proprietorship firm
Yes.
transferred to partnership.
Yes.
My lord, thereafter, a new agreement was entered into at page 66 with the IOCL on 21st day of November 23, page 66. The top, your lordship has got the date.
Hmm.
My lord, then your lordship will find at page 80, annexure 8.
Page.
80, annexure 8.
Yes.
My lord, where there was a complaint from one Gautam Kumar Kunda.
Yes.
My lord, the complaint says that the farm dealership, the distributorship was run in the name of him as on basis of a power of attorney.
Yes.
That was the complaint. And my lord, show cause was given to me seeking confirmation regarding that at page 81.
Yes.
Thereafter, my lord, I replied at page 82.
Yes.
My lord, thereafter the show cause notice at page 83.
Yes.
And I replied at page 86.
Ultimately terminated or
My
what?
lord, terminated. My lord, I will, some clauses I have to replace before, my lord.
No problem.
My lord, page
Yes.
86, I show cause. Then nothing was forthcoming. I approached this court and the order is passed at page 94.
This show cause you replied, show cause is at page 83. This is the show cause notice, isn't
My
it?
lord, my lord.
And 86 is
Reply.
the reply.
Page 94, my lord, I approached this court and there was a direction.
You approached this court at the stage of the show cause notice.
No, after the show cause notice, nothing was coming forward after the reply. So this was the, I approached.
Yes.
And that was the direction given by page 95, para 6 and 7.
Yes. Yes, please.
My lord. Then, my lord, they have terminated me at page 95.
No, what is the direction? Your
Direction, my lord, is page para 6 and
yes,
this
please
court-
read that.
This court has duly heard the learned counsel appearing on behalf of the parties.
Communicate the decision so taken.
While
The direction is to communicate the decision so taken. Yes.
They have communicated me on 22/9/25 at page 97, terminating me.
That is under challenge by way of the
My-
present
my-
repetition.
My lord, now the question will come before your lordship. What are the clauses for which they have terminated me? They have stated in the termination letter that at page.
Notice has to be given, Mr. Roy
My lord,
Chaudhary.
notice has to be given, but one thing I understand, my lord. Two things why I have come before this court in a writ petition, because there is in their rules, my lord, your lordship will find at page 120 that a personal hearing has to be given for terminating me. And there are two options. One is a major irregularity, minor irregularity, and critical irregularity. I fall in neither of them. Neither personal hearing was given. Now, in that ultimate termination order,
What is the rule of personal hearing?
page 120, my lord, I have given. 3.9, it starts at page 101. Marketing discipline guidelines.
Page 10.
It starts at 101. Page 120 is that particular clause.
101.
It starts at 101 and the
Relevant page.
relevant page 120, 3.9.
Under the SC/ST category, you are SC/ST category. 3 point.
CPG before recommending a termination after other than STC category will provide a personal hearing.
Other than, okay.
In case of ST, personal will be given by the state head in case of such and such.
So according to you, this was not given.
Not given to me. Another thing, my lord, your lordship, the clause they have stated.
That will not go into at this stage. Yes, sir. Hearing given, not given.
No, my lord. In fact, my lord, the facts are clear. What had happened, my lord, the details are the copy of the letter of intent was issued in the month of June 2011.
No, I'm not on that.
Yes, my lord.
The clause 3.9 says the concerned LPG head of state officer so and so,
Yes, my lord.
before recommending the termination of distributorship,
Yes, my lord.
will provide a personal hearing to the signatures to the distributorship agreement.
Yes, my lord.
What is this? Has it been followed, not
My
followed?
lord, as far
You
as
see,
aware-
if it is followed,
Yes, my lord.
no difficulty.
Yes,
If
my
not followed, then prima facie it will appear
My
that
lord.
where natural justice is not
No,
followed.
my lord, that's what I was submitting on, my lord. That natural justice is not an unruly horse, my lord. The facts are clear. Natural justice, my lord, in this aspect, even if a personal hearing was accorded, it will still be in violation of the guidelines.
Mr.
which were
Sharma,
written by-
those will be for the finer arguments that would forthcome at the
Absolutely.
time
My
of
lord,
hearing.
In fact, my lord,
Right now, only a prima facie case is required.
lordship will grant me only 5
As
minutes
of
to
now,
satisfy this court.
petitioner is showing that there is a condition for
Yes.
personal hearing.
Yes,
So
madam.
has this been done or
My
not
lord,
done?
that instruction is awaited from my end. I have to be very honest on that regard. But my lord will give me 2 minutes to satisfy this court. 2 minutes,
Yes,
my lord.
yes.
The letter of intent, my lord, at page 23. Page 23, my lord. The letter of intent in the month of June 2011.
Yes,
Page 23, your lordship sees that.
yes.
This was initially issued to petitioner number 2 as a proprietor, sole proprietor, my lord. Your lordship will come to page 24.
Yes,
You shall operate the distributorship personally and give us a written undertaking to this effect.
yes.
3.4, you shall not induct any partner in case of individual nor make any change in the constitution of the partnership as existing at the time of application without written approval from the Indian Oil Corporation.
That approval was taken subsequently.
My lord, but that's what I'll submit on, my lord.
Hmm?
Please,
No,
no, my lord.
huh?
That is a separate issue altogether, my lord.
No, but it was
It
taken.
was taken subsequently with subject to with
You have
different
given,
divisions,
where
my
is
lord.
that,
No,
where is that, Mr.
that-
Chaudhary?
no,
That-
my lord,
The problem is what the subsequent agreement has been terminated because of some, assuming also the power of attorney given in an earlier agreement. My lord, that novation will come.
Mr. Chaudhary, where is that? You just showed me one.
Page 63.
63.
63.
Approval was given.
The individuals are different, my lord. That is separate issue. Page 63.
We are pleased to inform you that reconstitution of MS Silchar Indian Service has been approved in principle by the competent authority. Reconstitution shall be agenda. This is for what? For the same
No,
distributorship?
No, my lord. No, my lord.
Power of attorney was
No,
all.
my lord. That is the detail, my lord. Petition number 2 and 3, their names find mentioned in page 63.
Yes,
Srimati Litirani Paul and Mariam Bibi Chaudhary.
yes.
Now, my lord, will come to page 27. This was the power of attorney which was executed. Page 27, my lord.
Hmm.
Your lordship sees that in the month of January 2012. Your lordship will come to page 28.
Yes.
The attorney holders, my lord, were Darjis Alam Chaudhary and Gautam Kumar Kaunda. This was a registered power of attorney. Your lordship sees that there is a slight, the details are
Page 27 is?
27 is the power of attorney, page 28, my lord,
Yes,
the first paragraph.
yes.
And whereas Mr. Jarjis Alam Chaudhuri, son of so and Mr. Gautam Kumar Kaunda, who is the initial, eventual complainant,
Yes.
will have invested and will invest further as and when required. So the approval which was granted by the IOCL was in regard to a separate individual.
No, my lord, here
Yes,
again it has been
No, my
confused.
lord, see your lord.
Earlier, there was an agreement which got automatically.
Mr. Roy Chaudhary,
My lord.
My lord.
while you were making your submission, the respondent side was not jumping up.
No.
Why are you disturbing? You have to say something, you say it later on. It's very difficult to hear both counsels together. We hear counsels by turn. Yes.
My lord. So after the LOI was issued to the petition number 2 initially, petition number 2 executed this power of attorney without informing the IOCL, entrusting the attorney power of attorney, my lord, to these two individuals at page 28.
Mr. Sharma,
Yes, my lord.
these things would require hearing,
No
but
stay would be
I am
warranted.
issuing
My lord, no stay would be warranted, my lord, because
till the next date.
my lord, what has happened is,
Sorry, Mr.
my
Sharma.
lord, this is in clear violation of the guidelines, my lord. The guidelines,
You could have satisfied today that the opportunity was given.
my lord.
Then there was no question of granting a stay.
My lord, my lord,
But
what has happened-
notices, copies are served in advance to the respondent counsels to get the minimum
Instructions, my lord.
instructions.
In fact, my lord.
This court doesn't expect a parawise comments and an
Absolutely,
affidavit of
absolutely,
opposition on the
No.
first date itself. But when there is a stay prayer in the writ
My
petition,
lord.
then you see
lord.
some homework has to be done by the other side as well.
The personal
Uh,
hearing, my lord, the
yes.
personal hearing would not
Heard
change the outcome. my lord.
One second, Mr. Sharma, I've heard you. Heard Mr. P.K. Roy Chaudhary, learned counsel appearing for the petitioner. Also heard Mr. M. Sharma, standing counsel,
Yes, madam.
learned standing counsel IOCL,
Yes, madam. All the respondents.
IOCL within bracket respondent numbers
1, 2, 3, 4, 5,
1 to 5.
6, madam.
1 to 6?
Yes, ma'am.
1 to 6. One to six, huh? By way of this petition under Article 2 to 6 of the Constitution of India, the petitioner is assailing the impugned termination order dated 22/9/2025 issued by the respondent number 2, whereby the LPG distributorship of the petitioner's firm IMS Silchar Indian Services was terminated due to breach of letter of intent dated 27/6/2011 and distributorship agreement dated 18/10/2012 and 21/11/2023. Stop. Mr. P.K. Roy Chaudhary, learned counsel appearing for the petitioner, submits that the termination has been issued without providing a personal hearing to the petitioner in violation of this. The name starts at 101. Violation of the market discipline guidelines of clause 3.9 of the marketing discipline guidelines 2022 issued on 1/5/2022 for LPG distributorship. Stop. Mr. M. Sharma, learned so and so, while vehemently opposing the prayer of the interim relief sought in the writ petition, submits that the LOI issued on 27/6/2011 to the
Petition number 2.
petitioner number 2
Yes.
clearly required the petitioner number 2 to operate the distributorship personally and not to induct any partner in case of individual, nor make any change in the constitution of the partnership as existing at the time of application without written approval from the Indian Oil Corporation. Stop. He further submits that the power of attorney at a power of attorney enclosed as Annexure 2 to the writ petition clarifies that one Jarjiz Alam Chaudhary and Gautam Kumar Kanuda Kaunda
The complainant, my lord. Yes.
has invested and will invest further as and when required towards the aforesaid LPG business, which is stated, which appears is of them or who?
Is by executed by the petition number 2.
No, the business of mine. What does mine mean?
Petition number 2. Petition number 2, my lord.
Of the petitioner number
Number
2. He further submits that no prejudice has been caused to the petitioner. He further submits that you don't have the instruction right now about giving the opportunity. That
Only
you don't
that
have.
had not-
Yeah,
the
but
rest
he
of-
further submits that though the instruction as whether opportunity has been given or has been provided whether personal hearing was provided to the petitioner before issuing the impugned termination order is not available with him today. However, assuming if the same is not provided, even in that case, no prejudice has been caused to the petitioner.
Yes, my lord.
Correct?
Yes, my lord.
Stop. Her issue notice returnable. Give a date after the holidays. On such and such dates, second week or deduct. On such and such date. You're accepting for all? Mr. So-and-so accepts notice for all the respondents. Extra copies within the course of the day. It appears that under clause 3.9 of so-and-so reads as under page 120. Where is the impugned notice, that termination? 97.
Speaking order, my lord.
22/9/25.
97 is the show or termination.
Termination letter.
It appears from the impugned termination notice dated 22/9/25 that pursuant to the show cause notice dated 24/7/2025, on the basis of a complaint received from Shri Gautam Kumar Kaundra,
Power of attorney holder, my lord.
one of the alleged
Initial power.
initial power attorney holder.
And the current petition number 3 is the wife of the initial Jarjiz Alam Chaudhary, my lord.
The inquiry was, the show cause notice was issued pursuant to which the impugned termination was done. However, it does not refer to any opportunity of personal hearing being provided to the petitioner before issuance of the impugned termination order. That being so, this court stays the operation of the impugned termination order dated 22/9/2025 till the next date of listing, relist on such and such date.
22.
It is the lordship. My lord, so here, my lord, The pursuant to a tender notice dated 19/8/2025, that is at page 15, my lord. The petitioner has submitted his tender by fulfilling all the required criteria, my lord. But, and your lordship may kindly turn to page 15, sub-para 2, my lord, second para.
Yes.
Tender will be accepted on 26/8/2025 up to 2 p.m. in the office of the Folimari Gaon Panchayat, and the tender will be open on the same day at 3 p.m. in presence of tenderers or in presence of the representatives if no problem arises. But no tenders were open at that particular time, as fixed by the my lord authorities. And this is the criteria, one of the criteria of this.
What are you
notice.
seeking in this writ petition?
Here, my lord, the tenders were not open and the petitioner had no knowledge that subsequently it was open, because as per this tender notice, my lord, the tenders should be open in presence of the tenderers.
Okay.
So only on 2nd of September, the petitioner came to know that the private respondent has been given the settlement behind the back
Given
of the settlement of the ghat, for which the petitioner has submitted his tender, my lord.
All right, I'm going to issue notice and make it, that will be remain outcome of the court, outcome of this case.
Yes, my lord.
Nothing more. Heard MS
SB Chaudhary.
SB Chaudhary, learned counsel appearing for the petitioner. Also heard Mr. A.K. Ghosh, learned standing counsel.
No, no, on behalf of Mr. S. Datta.
Huh?
On behalf of Mr. S.
On behalf of,
PNRD standing counsel.
on behalf of Mr. S. Datta, learned standing counsel, PNRD, and Mr. Bokolia.
Yes.
Mr. So-and-so Bokolia, learned state counsel. For respondent numbers?
7.
7. Any private respondent is
Yes.
there?
Yes, my lord.
Okay. By way of this writ petition under Article 226 of the Constitution of India, the petitioner is assailing the selection of
Private respondent.
the private respondent for settlement of Bajar stroke Ghat stroke Min Mahal stroke Pond under the Fallimari Gaon Panchayat.
The name of the ghat is Majerchor via Kunti.
Where do I get that?
It is in the synopsis itself, my lord.
No,
The
in this
section
annexure A, which one is yours?
Annexure A is the my lord tender notice, and here this is 2, my lord, number 2. Not
Dhubri Parghat.
that ghat is, the name is different, my lord.
Where is that? Where do I find that page 15? It's not there.
My lord, relevant portions were translated, my
But
lord.
where is it? It is not there.
It is in
It's
the,
not.
my lord,
It is not there. Only
it-
2 is
it-
there.
It is in the vernacular, my lord.
But they should have
But-
been there.
Vernacular page 17, my lord.
But Miss
Page
Counsel,
17.
you should have been more vigilant. Who has wrongly given?
My lord,
Who
the
has
type
wrongly
was
given?
wrongly typed, my lord.
Who has wrongly typed?
The typist, my lord.
The typist.
the
And it is
original-
who has certified this writ petition?
My lord, I have certified,
Then
but originally.
Who has filed the writ petition? Miss Counsel, you have to be more careful. You are challenging this selection, and that particular details is not in the language which is required to be there. The translation should have been more careful. This is the whole genesis of the case, page 15.
Yes, my lord. Page 17 is the vernacular, my lord.
Provide a correct copy.
Yes,
I'm issuing notice, but you provide it.
yes, ma'am.
In your pleadings, where do I find that?
In the pleadings, my lord, in para 2, my lord. At page 7.
কি বলে লিখিলা?
7 and 8.
For settlement of the Majuchar via Kuntrichar to Dhubri Parghat. Is that the one?
Yes, ma'am.
No issue notice, returnable 4 weeks, and so and so and so and so accepts notice for so and so, registered post AD by steps by 3 days. let the proper translated copy of the notice so and so and encloses annexure A to the writ petition be provided by the writ petitioner, by the learned counsel appearing for the petitioner to the registry for doing the necessary correction. Yes.
Time being item number 2.
Yes, Mr. Dekka?
My lord, this is the third round of litigation, lordship. In this case, lordship, I'm challenging the impugn order, which lordship would find it 102.
102.
But before starting, lordship, before perusing that, lordship, I would like to brief what is the facts of the case. Initially, lordship, an e-auction was given, and we have participated in it, and we were the highest bidder, lordship. Lordship, that e-auction is at page number 36.
You are the highest bidder?
Yes, lordship. After
Yes.
after that, we were granted and we were allowed to submit the EMD, lordship, and that is 25% as per the e-auction, and we have submitted that EMD, lordship. After that, subsequently, lordship, on lordship 4/4/2023, my bid was rejected on the ground that I did not satisfy one clause, that is clause 14 of the e-auction notice. After that, we have filed a detailed representation before the court saying that before them, lordship, that clause is not applicable to us, and kindly recall the order. Then, lordship, they did not do so, lordship. After that, lordship, we have filed a writ petition. In the writ petition, the court has granted 1 month time to decide the matter. Then subsequently, it was not decided for a period of 2 years. And after that, I have filed another writ petition in this year, in 2025, after which 3 weeks time were granted.
That is 2383.
2383, lordship.
Yes.
3 weeks time were granted, lordship, and after that, the impugn order is passed. Now, lordship, I would like to take your lordship to what is the ground. Lordship, may kindly see 4/4/2023.
So this impugn order is 11/6/25.
Yes, lordship.
However, in view of the sensitive nature of the
Yes.
matter and issuance of earlier communication, and as the EMD has already been refunded,
Lordship.
the order dated so and so is not recalled.
Lordship.
What
No.
is the order of order that you wanted to be recalled?
Lordship would find that in page number 53, lordship. Lordship, the typed copy, lordship, would find at page number 51.
Yes.
Lordship, I am the company, lordship. And I just like to read it, lordship.
Yes.
With reference to the above, I inform you that on scrutiny of your bid and other relevant documents, it is found that you have failed to comply with the terms and conditions emphasized in clause 14 of the e-auction notice as on date of the e-auction, and as such, your bid for sale of the property of Fatimabad Tea Estate held on 14/3/2023 has been treated as cancelled on the aforesaid ground. Now, lordship would kindly peruse what is the clause 14, lordship. That
Wait, Mr. Counsel, we are not going to hear the matter right
Lordship.
away.
Lordship.
Now,
lordship,
there is no difficulty for issuance of notice, but nothing more at this stage. This court is not going to give any stay for not going for fresh till the next date. That order at this court is not going to give on this basis.
only thing, lordship,
We can fix it on the returnable date and keep the interim open. That much we can do. Heard Mr. P. Dekka, learned counsel appearing for the petitioner. Also heard Mr. P. N. Naik, learned standing counsel, ATE.
I'm not a standing counsel. I'm appearing on behalf of 2 and 3 counts. On labor department.
2, 3.
Yes, sir.
So additional advocate general.
Not as additional.
Then?
But as a counsel for APT, yeah.
Learned counsel appearing for respondent number 2 and 3. And Mr. Bokolia for 1. State counsel for 1. By way of this petition under Article 226 of the Constitution of India, the petitioner is assailing the letter dated 11/6/2025 issued by the respondent number 3 to the effect that the respondent authorities, despite acknowledging that the petitioner is not a defaulter, refuse to recall the order dated 4/4/2023 and give the possession of the Fatimabad Tea Estate to the petitioner being the highest bidder in the auction process. Issue notice, returnable so and so, so and so and so and so accepts notice. Relist on, yes, Mr. Nayak? After 4 weeks on a date to be fixed by the registry, interim to be considered after return.
I have some objection so far as that interim is concerned. This is a decision, Lordship, of the year 2023.
You make your submission on that.
And Lordship,
Yes.
if I may,
Next.
if I may, Lordship,
Next.
pendency of the case.
No, nothing.
Lord,
Next.
apply. I know.
Pending item 20.
I'm sorry,
Yes.
my lord, I'm sorry, my lord, I was on.
No
yes.
problem, Mr. Bhuya. Yes.
My lord, this is a matter, my lord, relation to, my lord, the election of the president and vice president of a particular Gaon Panchayat, my lord. My lord, as per the state.
President and vice president.
My lord, president and vice president is the, my lord, has not been elected or selected, my lord, in accordance with the provision of the rule, my lord. There was in fact no meeting was held and some external forces, my lord, on the day of the meeting causes disturbances. And therefore the present petitioners, my lord, could not exercise their voting rights in accordance with law, my lord. That's why the election of the president as well as the vice president is under challenge, my lord, in this petition. My lord, we have also made a representation before the deputy commissioner, my lord. Section 11 of the Panchayat Act says that, my lord, the such issues can be raised before the deputy commissioner, my lord, and the deputy commissioner is required to resolve the issue. If just for a moment, my lord, if I may be permitted, my lord.
Yes. Yes.
Dada. Twenty-eight. My lord, page 28, section 11, my lord.
Section 11.
My lord, in my book, my lord, it is at page 28.
Yes. Any dispute
Any dispute relating to the validity of the election of the president and the vice president of
shall
the
be
town-
decided by the deputy commissioner.
My lord. So, my
Yes.
lord, we have made a representation before the deputy commissioner.
Where is that
My lord, may
representation?
be pleased to find is at page 53, my lord.
Page 50.
53, my lord, annex of 5.
You want disposal of that representation?
That can be because, my lord, some disputed facts are there, my lord. We have said, my lord, that there was no election in accordance with the law, my lord. The voting rights could not be, my lord, discharged in accordance with law. If my learned friend agrees, my lord, the deputy commissioner can take a call by hearing all the sides and can pass a reason order by speaking order, my lord.
Yes.
Page 77 for timing, my lord. This is the third time litigation under the same cause of action.
No, but without going into all this, it appears that there is a power of the deputy commissioner under section 11, right? If there is any dispute relating to the validity of the election. Now that complaint has been filed and on 8/7/25.
Election was held on 9/7.
So, but then the DC can always.
Yes.
When was the election held?
My lord, it was in fact.
Mr. Counsel, when
9/7.
9/7?
25 months.
And but the complaint is before 9.
Yes, ma'am.
No, my
How?
lord, it has been acknowledged on 9/7, my lord. It has been wrongly written as 8/7. If my lord may be pleased to find this initial at the top, my lord, the district commissioner, Kamrup, it is a signature of 9/7, my lord, very not legible, but it is on 9/7/2025, my lord. I have inquired on. Lord,
Will you please read that 53 letter?
My lord, may I draw my lordship's
No, you
attention?
read.
My lord.
With due respect.
Yes. With due respect, we beg to state that we are the ward members of the Horodatta Gaon Panchayat. Your Honor, after the Panchayat election, the ward members elect the president and vice president as per the Panchayat Act. In this connection, the district administration fixed 27/6/2025 as the date for the election to the post of president and vice president. But due to political conspiracy, without issuing any notice, the election was postponed and fixed on 4/7/2025. On the said date also, we were returned from the IB bungalow situated at Septi, and today the date was fixed on 9/7/2025 and we were invited. Accordingly, we were present, but some miscreants not associated with the office were present there since earlier in presence.
English is little, but otherwise looks like it is on.
Should be either.
No, no, my lord, what
Particularly
I have-
error, my lord, it should be 9/7.
Nine.
I think.
My lord.
So we can dispose it of them.
My lord.
Heard Mr. A.R. Bhuya, learned counsel for the petitioner, also heard Mr.
And thus, my lord.
N. Das, learned standing counsel,
No, my lord, 234, state council.
learned state counsel for respondent number
234.
234 MS. P. Thapal, learned standing counsel, learned counsel appearing on behalf of Mr. S. Datta, learned standing counsel, PNRT. By way of this writ petition under Article 226 of the Constitution of India, the petitioner is assailing the election of the president and vice president of the 96 Haradatta Gao Panchayat
My lord.
held on 9/7/2025 on the ground that the same is vitiated by gross irregularities, illegalities and violation of statutory safeguards under the Assam Panchayat within bracket Constitution Rules 1995. Stop, Mr. Bhuya, particularly Rule 46
sub-
and
Sub-rule
8. Mr. Bhuya, learned counsel for the petitioner, draws the attention of this court to a complaint dated 9/7/2025, to a complaint stated to have been filed on 9/7/2025 before the District Commissioner Kamrup, within bracket respondent number,
Got the, 2, my lord.
respondent number 2, to look into the anomalies that is stated to have been occurred in conducting the election for the said post of president and vice president. Stop. He further refers to Rule 11 of the Assam Panchayat Act 1994, whereunder it is provided that any disputes relating to the validity of the election of the president and the vice president of the Gao Panchayat, if any, occurs, the same shall be decided by the deputy commissioner.
Instead of rule, it is section, my lord. Section 11.
Section
Wow.
11.
If-
In view,
For time being interfere, I find it interesting, my lord, page 53 for time being, my lord.
yes,
Last portion, my lord, your honor, we do not feel secure in conducting the election process in Rongia, as such to ensure the fairness of the election to the post of the president for safeguarding the interests of the republic. If pray to conduct the election in your office under your presence. Election has already been over, my lord. On 9/7.
No, no.
yes, so
It is over.
that's
why we
that's
make
why they are
complaint.
saying dispute is to the election.
To have
No, election হয়ে গেল।
In view of the fact that in the event there is a dispute to such election as provided in view of the fact that under section 11 of the so and so rules, in the event there is a dispute relating to the validity of the elections to the post of president and vice president of the Gao Panchayat, the deputy commissioner has a power to decide the same. This court deems it appropriate to dispose of this writ petition in the interest of justice at the motion stage itself by directing the deputy commissioner to dispose of the representation as filed before the respondent number so and so by letter dated 8/7/2023 within a period of
And that's 6 weeks, my lord.
6 weeks from the date of receipt of the certified copy of the ordered
In
accordingly,
accordance with law.
in accordance with law.
From the DC will pass a speaking order thereof.
Yes, next.
Oblige, high level.
Iman? 23.
May I please, your lordship? Lordship, Mr. DP was pending counsel of health department is on Lake Lordship, so matter may be taken up after some time now.
You should have informed Mr. Sharma. He's been here since morning. No, after some time.
I'll be here.
Be here. Affidavit kon ahil nai.
It has come. For admission, item number 4 for dismissal.
Item number?
4.
Oh. None appears for the petitioner on call. It appears that since there were no appearance on the last two consecutive dates, i.e. 5/9/2025 and 22/9/2025, the said writ petition was directed to be listed today in the admission column for dismissal, with the remark for dismissal. Despite the matter being listed in the cause list with the remark for dismissal and the names of 4 learned counsels appearing on behalf of the writ petitioner being reflected in the cause list, there is no representation. Writ petition stand dismissed for non-prosecution.
5.
May it please your lordship? Lordship, we have received a copy of the affidavit in opposition, lordship.
You want to file a rejoinder?
Lordship,
As prayed for by MS.
M. Das on behalf of.
M. Das, learned counsel appearing for the
P. Mohanta, lordship. Of P.
appearing on behalf of
P. Mohanta.
no, so and so on behalf of P. Mahanta, learned counsels for the petitioner, relist after 3 weeks on a date to be fixed by the registry to enable the petitioner file rejoinder against the affidavit in opposition filed by
My lord, respondent number 1, 2, and 3. My lord.
Respondent 2.
Two.
Respondent 2 has.
2. All right.
Item 6.
Lordship, may I pray that the matter may be taken up after some time, your lordship?
But there are not much matters, so be here.
Orders, item number 7.
May I please, Lord? Lordship, this matter relates to land compensation, my lord. All that time, they have given the assurance, my lord, to pay the compensation. Sometimes 1 week, sometimes 2 weeks, like this, my lord. Nothing has happened, my lord, as on today, my lord.
Contempt matter.
Lordship, Lordship will have a look, order
Yes,
that.
Mr. Chalya.
Lordship, if my learned senior just goes through this instruction, Lordship.
What is your instruction?
Lordship, we have transferred the amount in the DC's official account, Lordship. He needs to make the payment. We have already informed him.
Mr. Chetri, you have a look at it. I'll call it after the next matter.
Lordship.
Just
yeah.
in the meantime, have a
Yes,
look at
Lord.
it. Next matter to Pisat Mandi debate.
Item 8.
Yes,
Service completed.
service completed. Anyone appearing?
I'm my lord.
State council 234.
Mr. Das, what about your return?
My lord, but this pair-wise comment is not sufficient, my lord. Only no.
All right, so that's why I'm asking you.
I will tell.
Mr. N. Das, Learned State Council submits that though his office has received the pairwise comments, however, the same is not sufficient and accordingly seeks some further time
6 weeks.
to enable him to file the return. Prayer is not opposed, relist after 4 weeks on a date to be fixed by the registry. Not 6 weeks. Those days are gone. We cannot keep matters pending for so long. Yes.
7.
Yes. My lord, that communication has been made. Only my prayer will be, my lord.
No, what I can do is I can keep this matter on the I'll put it on the reopening date. In the meantime, you get your instructions.
My lord, no, my lord, only I have been told, my lord, it has not been paid as on today.
Yes. That 2 days. 2 days.
No, because that is because it is only been
And-
transferred.
Yes,
Yes,
it has
Lordship.
been transferred to Deputy Commissioner. Only my prayer will be before Lordships.
that let the this district
You see,
commissioner.
Mr. Chetri, the problem
complete
is
the-
this is
complete the process.
this is a contempt case. I cannot give any orders. This is not an executing court, but who is appearing for the deputy commissioner? You are appearing.
No, DC is not a party, Lordship.
This is
No,
not a
this is,
party here.
no, this is the party.
No, in the contempt.
Yes, contempt.
No, Lordship, that's the old deputy commissioner. I don't know if he's still holding the post.
হেৰি আকৌ ভৰালি আহিলে না তাৰপিছতো আহিলে ভৰালি
Party.
নাই নাই এড কৰিলো এইটো
Lordship, I'm not, DC, I'm not.
Mr. Cholia, it's all right.
now G Pegu is appearing.
Where is he?
Kirin Pegu,
If he is here, we could ask him.
he is not there today.
Name R3, Lordship, SS Roy's name is showing for R3, Lordship. I'm not
SS
aware
Roy G Pegu
If,
পিছত আকৌ কৰিছো তো এইটো
Anyway, councils, you sorted out outside the court all this. Heard Mr. B. Chetri, Learned Counsel for the petitioner, also heard Mr. A. Chalia, Learned Counsel appearing for respondent stroke contender number
one Lord.
1. Mr. Chalia submits that the instructions for release of payment has been issued to the office of the district commissioner, stroke contender number.
Lordship, if.
contender number now 7, my lord. Included respondent number 7.
I'm not finding the amended cost title. 5 is there, then
7.
7.
Yeah.
Ankur Bharali,
Yes.
respondent number 7. However, there is no representation on behalf of respondent number 7 on stroke contender on call today. Relist on such and such date. Date after vacation. And then I'm not keeping any copy. You file it. In the meantime, let the instruction dated so and so be placed on record by way of an affidavit. In contempt matters, I have stopped. This court has stopped taking papers
Only
in such fashion. No, nothing. Not even for reference.
My lord,
It's a contempt case. You file that. Yes, next.
deputy commissioner will comply, my lord.
Next.
That part.
Mr. Chetri, this is a contempt proceeding.
Lordship can.
So I cannot do it. Yes,
Because-
next.
Tell. Lordship fixing the on 13th.
Yes, next. Yes, Ms. Devi.
Let's see, this contempt petition is filed, let's see, against non-payment of the compensation amount, let's see, for the land acquired from the petitioners. The respondent number 1, it is he has filed one affidavit, let's see.
Who are the contemners? You all have
Let's
filed
see,
your
let's see,
affidavit?
office-
Yes, sir, Lordship.
let's see, Office note dated 24/9, let's see.
Yes.
Says,
AD card nor unserved notice
That's it.
received back from 2 and 3.
let's see.
So you are for?
1.
And you are for? 1. So 2 and 3 are still awaiting.
Let's see.
Await service in respect of respondent number 2 and 3. Relist after 2 weeks on a date to be fixed by the registry. In the meantime, you have already filed, right?
Yes.
Let's
Don't say in a minute. It is, it appears that respondent stroke contender number 1 in the meantime has already filed their affidavit in opposition in the matter.
Let's see, date this.
Next.
Item 12.
Okay.
None appears for the petitioner on call. Released after 3 weeks on a date to be fixed by the registry.
Pending item number 6.
And in this case,
Yes, Mr. Majumdar.
some subsequent development has taken place, which we have brought on record by way of an additional affidavit. Whether that is on record or not.
No, that is not on record, Mr. Majumdar. Mr. Saikya, you have received?
I have received, madam, that.
All right, I'll post it after the vacation then.
That doesn't have any bearing on the.
But
issue.
it has to be on record, Mr. Saikya. Heard Mr. D. Majumdar, Learned Senior Counsel, assisted by Mr. S.K. Deori, Learned Counsel for the petitioner. It appears that the additional affidavit, no, Mr. Majumdar submits that an additional affidavit has been filed when?
Yesterday.
Yesterday, I so-and-so did to bring certain additional development on record. However, the same is not available in the record today. Let registry verify and place the same on record. Tarup, agot didiba, Mr. Saikya, Learned Counsel, appearing for Senior Counsel assisted by Arketa Talukdar submits that his office has been served with the said additional affidavit. Then registry verify and place. Yes, list on
17th, madam.
Mr. Saikya.
Interim order may continue.
Interim order, if any, shall continue till the next date of listing.
And please, your lordship. What saying Mr. DP Bora is still on legs?
20?
3.
23 is which matter? Yes, Mr. Sharma, your matter.
Yes.
23.
So Lordship has
Yes.
given this order yesterday,
Yes,
and only Lordship can see this is the fact, Lordship, paragraph 3, 4, and 5.
yes,
And Lordship, remember,
yes.
and that Dibrugarh method, Dibrugarh Medical College, there they said that it is not a ZEM tender. So we should go by a ZEM tender. Here it is a ZEM tender, and I am the lowest. Now here this problem, and this court has given a particular order to a particular date. After that also the petitioner is running the show. Not
Where is an
giving-
additional affidavit? As well as Mr. Barwa.
An agreement is signed, everything is done, Lordship.
Where is
Now-
Mr. Barwa?
Sir, he is still on leg.
Mr. Barwa. AK,
Still on legs.
DP Barwa or
DP Bora.
huh? DP Barwa is on legs, but what about Mr. AK Barwa?
I'm coming.
Additional affidavit from court, sir. কিবা এখন ফাইল কৰিছে না আজি? 160 page.
Lordship. Nothing, Lordship. He has given a Tezpur Medical College order. There, Lordship, some food quality and all that document has given and the order. So I am not concerned with all this.
Let's wait for him.
Yes, sir.
Let me hear Mr. Barwa and Bora, and if anything is required, then I shall hear you. But it is only for the
Yes, yes.
non-extension of the interim order. That is your prayer.
Yes, sir.
It is today, operating till today.
In fact, interim order also there is nothing, Lordship. Your interim order is clarified, Lordship, that after a particular date they cannot continue.
So now
No,
the question is
no,
a
there is-
third party.
Yes.
Now he has an objection to, he doesn't have an objection for any other party but to you.
Yes.
That too in a process where you both had applied.
Yes.
Where you had been selected and he was not.
And he joined the tender and after that silence, Lordship.
Mr. Deka had very elaborately placed
Yes.
the arguments for the applicant yesterday, so I remember.
He has some bereavement.
No
so I
problem,
have to
no
come,
problem,
Lordship.
no problem.
Burma died, so he won't.
No problem, Mr. Sharma. Has somebody calling him? The difficulty is that the rest, all the matters are over, Mr.
I know,
Sharma.
Lordship, in the morning I'm sitting, Lordship, and they very nicely, yeah, Lordship.
Take a sip, take a seat. Are you comfortable? You want a glass of water?
No, my lord, I'm fine.
Yes.
So yes,
I see you have filed an affidavit in opposition of 160 page.
No, it's 80 pages, my lord.
80 page.
They filed an affidavit of 79 pages.
This affidavit in opposition, this is yours.
Yes, my lord. It starts at 80 and it ends at 60.
Oh.
160. Therefore,
That's how.
that's how.
I got the last
My
page.
lord.
Anyway, that
I had to place all the.
no, of course. That's why waiting for you.
My lord.
Yes.
May I just put some context?
Yes.
In the background facts.
Yes.
Now, my lord, in the year 2020.
But please remember that this court is only hearing this interlocutory application which you have not filed, which has been filed by them
Yes.
to modify the last interim order to the extent of allowing a third party to run and not to finalize the NIT.
NIT.
These were the two things which they want
Yes.
a modification. So confine your arguments. You may argue the whole day. I do not have a problem, but your argument should be confined to only that, not to anything else, because you have not come with an application for anything today.
I would like to show from the record how the court's order were willfully disobeyed. Now, if your lordship kindly takes up the affidavit in opposition for a moment.
Yes.
May I just place the basic facts?
Yes.
Without referring to any of the pages.
Yes.
2023, my lord, the Nagaon Medical College was established. On 16/2/2023, the opposite party number 6, they wrote a letter to me stating that we have set up a new hospital and we will require your services for dietary services. And as such, there was an agreement between me and the state authorities, which your lordship will find at page 103. And it starts at 103 and the relevant portion is at page 104. Clause number 1.
Yes.
It says, the allotment of contract to run the diet section for supply of diet to the inpatients of the hospital for the period of 2 years with effect from 23/2/2023 in the form of outsourcing and is to be subject to fulfillment of terms and conditions. So, my lord, the tenure of the agreement between me and the authorities was for a period of 2 years with effect from 23/2/2023, which would mean my agreement would expire on 22/2/2025. Now, in the meantime, the NIT came, the NIT in question, the NIT dated 8/11/2023. We participated in the NIT under the belief that the work will commence after the expiry of my existing tenure. Thereafter,
Mr. Verma, see, if you want this court to appreciate what you're saying, that first you just tell me what is the point that you're trying to draw home.
The point I'm trying to draw before your lordship, and what I want to bring your lordship's kind attention is to the fact that a fraud has been played before this honorable court.
By whom?
By the applicant as well as in collision with the authorities.
But you see, today you have not come up with any application. I'm not hearing any application from your side. Correct? That is why I am telling you, your writ petition is not being taken up for hearing today.
No,
now you have to understand what is the interlocutory application which the prayer of which you are opposing. Because that order was filed in your presence.
Exactly.
That order recorded one position which you are not challenging, that your tenure had expired. Correct?
Correct.
You have not come up for vacating that order. One second, please hear out. You see, as I said, I have cleared my board and I do not have any difficulty of going on with this hearing. But you see, you are also an officer of the court. So understand what is the situation.
Absolutely.
You want an audience, this court will give you the audience. But you, and that order also records that the status quo which was granted in your favor on the first date is vacated. Correct?
Correct.
So that part of the order, you are not seeking any modification, vacation or clarification. That part of the order stays intact. Now the second part of the order is to the effect that because now that your tenure has come to an end,
exactly,
there is none to supply the dietary. That cannot be the situation. It is in that premise that the court has ordered, subject to correction. I think it was on that premise the court had ordered that you can take it from a third party, and because the impression was given that the NIT was not finalized, not to finalize with the NIT.
Exactly.
Now, the IA has been filed by the respondent number 5 showing that there was a tender process where both the parties had participated, including the petitioner. The respondent has become the highest bidder and he has been awarded. In fact, he was finalized. you see, those are the papers. That is why the authorities have been also asked. Now, there are papers to show that it has been given to him, that final work order was issued, agreement has been signed, executed, correct? Now, they are showing it.
Under what circumstances?
Whatever be it.
No.
But these things were before the date of the interim order, that particular date. Now, this is what has come from the other side. So that indicates that perhaps some development was there. Today, the matter was, that is why, of course, giving you also the chance to show something else. But the primary reason why the matter was kept today is to giving an opportunity to the Hill side to show that if that position is factually not correct. Till now, Mr. Bora seems to be busy in some other court. Anyway, so therefore you keep that in mind. I am not going to the history of frauds right now. We are not on that.
I am 100% sure after I finish
Now, if you, because I remembered yesterday you said, no, it is being run by a third party.
Exactly.
So what is that position? Where is that from your affidavit? Have you said that something?
Can I just show the
Yes.
basic facts
Yes.
initially, and then your lordship will take a call.
Yes.
But let me place some context in the background facts, my lord. Now, what had happened after the comparative statement was prepared, the work order was not given to the applicant. So what the applicant did, he approached the honorable court.
Applicant?
Yes. There's a previous litigation, my lord.
Yes, I remember.
Yes.
That was shown.
Exactly.
Yes.
So there's already a previous litigation. They filed 1878 of 2024. And this is what happened on 8/4/2024, page 120, my lord. Kindly come to page 120. So the applicant challenged for non-issuance of the work order, and notice was issued, page 120.
Yes.
And if your lordship kindly turns to page 121, the second paragraph,
Yes.
it says, be that as it may, the pendency of this writ petition shall not be a bar for the committee constituted by the principal cum superintendent Nagaon Medical College may take appropriate decision, but the same shall not be finalized without the leave of the court. So the learned Singh, the coordinate bench said, don't finalize. They simply issue notice. Now thereafter, the authorities asked the applicant as to how they will provide quality food at such a low rate. Kindly come to page 57 of the IA filed by the applicant. Page 57 of the interlocutory application.
Yesterday, some order was shown by Mr. Dekka in that writ petition.
I'm just showing, right? Kindly come to page number 57 of the interlocutory application, which is filed by the applicant.
Page
57.
Yes.
Notice was issued in the matter on 8/4/2024. On 18/7/2024, the opposite number 5 writes to the applicant, and this is what he writes. Sir, this is to inform you that as per report submitted by the chairperson and other members of the committee to look upon the matter of supply of diet to the patients of NMCH, Nagaon, the chairperson along with the committee members expressed their concern on maintenance of good quality and standard of diet to be supplied for indoor patients at the rate proposed by you. So they had expressed concern. It has been observed by the chairperson and members of the concerned committee that in the various medical college of Assam, the rate of diet supplied to the patients is higher to meet the various expenses. Therefore, you are requested to explain as to how you will be able to maintain good quality and standard of diet for indoor patients of NMCH Nagaon at the lower rate proposed by your company.
Yes.
So 18/7/2024, the opposite party number 5 seeks some clarification from the applicant stating how will you provide good quality food at such a low rate?
Yes.
Because the purpose behind this tender is to provide good quality food to the patients. And
Yes.
these are not my lord, normal patients. We don't go there. The poorest of the poor go there. It's a Nagaon government college, my lord.
Applicant is respondent number in the original writ, respondent number?
He is, my lord, in the respondent number. 1 second, my lord.
No, all right. Anyway.
He is the private respondent number 5 in the connected writ petition.
And in this IA, the principal is respondent number 5?
5. Opposite party number 5, my lord. And in the repetition, he is the respondent number
Four.
three.
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 Okay.
So
Yes.
respondent number 6, a clarification. Now, moment this letter was issued, what the applicant does, he files an IA challenging this letter, page 122.
That also I remember some order.
Kindly see, my lord.
Page 1. Oh, this is in your.
In my running page 122.
That is the complaint. No,
that
that
is the order by this coordinate bench of this honorable court.
120.
122 it starts. Relevant portion is 125. 125, my lord. Relevant portion. Honorable Justice, my lord.
Page 125.
Kindly see the third paragraph.
Yes.
The present IA is filed seeking stay of communication dated 18/7/2024 issued by the respondent number 4. Basically, they were seeking a stay of that communication. And if your lordship kindly skips to the 5th paragraph, it is the further instruction of Mr. Bora, learned standing counsel of the health department, that the authorities are having apprehension that at this rate quality food cannot be supplied.
Yes.
Now, this was an order passed by your lordship on 11/9/2023. The matter again was listed on 18/9, and this is what happened on 18/9. Kindly come to my lord page number 128. It starts at 128, and relevant portion my lord will find at page 129.
129. Yes.
The first paragraph. May I just read on, my lord?
Yes.
At this stage, Mr. Bora, learned standing counsel for the health department, submits that the work order is not issued to the petitioner for the reason that the rate quoted by...
Slow, Mr. Barwa. Slow. Yes. At page 128.
129, my lord.
Oh.
128 it starts.
Okay.
And 128...
At this stage, yes.
I'll read it slowly.
Yes.
At this stage, Mr. Bora, learned standing counsel for the health department, submits that the work order is not issued to the petitioner for the reason that the rate quoted by the petitioner is too low, and at that rate, nutritious food cannot be supplied. Mr. Bora has obtained instructions to the effect that the authorities are interested in having a negotiation with the successful bidder so far relating to the price, inasmuch as according to the authorities, the price quoted by the petitioner may result.
This is in connection with the subject tender.
Yes, my lord.
Same
tender.
Same tender. Okay.
Tender dated 8/11/2023, my lord.
Okay.
This writ petition filed by the applicant.
Okay, I understood. Yes.
After the same NIP.
Got it. Yes.
Now, my lord, in the second paragraph, your lordship will see, I've already pointed out the last line, inasmuch as according to the authorities, the price quoted by the petitioner may result in supply of poor quality of dietary articles.
Now, where are you reading now?
My lord, that second paragraph, my lord.
Mr. Bora.
Mr. Bora has obtained instructions to the effect that the authorities are interested in having a negotiation with the successful bidder so far relating to the price.
Inasmuch as, okay.
Inasmuch as according to the authorities,
this is in context with that letter which you had already shown.
Exactly.
All right.
Once the authorities sought an application from the applicant that's stating the how at this rate you will provide good quality food, because ultimately, my lord, these are all businessmen.
Yes. Thereafter, read that other submission of Mr. Sharma.
And
at this stage,
Mr. Sharma submits that the petitioner is having no objection or any negotiation as is admittedly successful bidder. And
Mr. Bora
on instruction further submits that the petitioner may visit the office chamber of the respondent number 4 for such negotiation at 2 p.m. on 29/2024. In view of the aforesaid, this court refrains from passing any restrains from passing any further order, and accordingly provides the parties may sit over the matter as proposed at 2 p.m. on 29
and settle the issue.
So
that was done.
So there was no direction from the government.
That was done.
So that was done.
Negotiation.
So what happened after?
What happened on 29/2022?
Private negotiations took place between the applicant as well as the authorities. Closed door. And what they do, my lord, they take a decision to award the work contract to the applicant, which your lordship will find at page 132.
No, any other document to show what happened on 29/2024?
Page 132, my lord.
132.
132.
Yes.
Subject matter is regarding negotiation of price for diet supply.
Yes.
And they give a reference of the High Court order as if the High Court has ordered.
Yes.
And the last paragraph, my lord, will see page 132. In view of the above, it is decided that Messrs. Ranjit Borua, who is the applicant, is to be awarded work order for supplying diet for the patients for 1 year with effect from a date to be decided once the guidance as mentioned in paragraph 3 above is cleared. So they did not decide, but then they decided to award the work contract. And on 3/10/2024, my lord, both the writ petition and IA were closed.
Yes.
My lord will find at page 135.
Yes.
So they close saying that the matter has become infructuous.
All right.
Now, on 29/2024, this work order was issued, and we became aggrieved. We became aggrieved because our original tenure for 2 years was curtailed because of this work order. When they had nobody, they were a new medical college. I was the one who had volunteered, and in fact, I provided food on no profit, no loss basis. But once they issued this work order, we got aggrieved naturally because, my lord, our tenure was curtailed, number one, and number two, my lord, the price bid which was quoted by
You were selected by way of a tender.
No, because that was a new medical college. 2003, the medical college, 2020.
So if a new medical board college's medical hospital, government hospital is constituted, tender is not required.
My lord, I did not know the exigencies of the.
Anyway, I'm just asking.
I understand. I don't know the exigencies of services at that point of time, but that is not under challenge in any repetition.
All right.
In any case. Now, my lord, once I became aggrieved, I approached this honorable court.
Yes.
And this is what happened on, my lord, page number kindly come to 138. It starts at 138. The order dated 28/10/2024. And I'll just point out the relevant portion.
Page number?
It starts at 138, my lord. And relevant portion, my lord, will find at page 141.
138?
138, my lord.
Yes.
We became aggrieved. We said, how?
All right, that I've understood. Now what happened here?
And what happened on page 141?
141.
It's a relevant portion.
You at that time you challenged the advertisement, the NIT.
No, I challenged the decision of the authorities to award the applicant the work contract.
So that is you're challenging in the present.
In the connected writ petition.
So this is that writ petition order.
That writ petition, connected writ petition. For your lordship's convenience, I have annexed.
Oh, acha. So the 5479 is the one where this IA has been filed, right?
My lord?
Yes, yes. No, I got a little confused here.
My lord.
Anyways, this is the order I think we saw also the other day.
Exactly. Now, may I just point out page 141, paragraph 5.
This is that order, I think, which Mr. Bora, you had also shown, right?
Yes,
this
yes.
is that order.
That order. Justice Michael's order.
Yes.
Honorable Mr. Justice Michael.
Yes, the issuing, the date on which the notice was issued.
Page 141.
And status quo was given.
And paragraph 9, my lord, will see.
Yes, that's status quo, I remember.
This court is of the view that the matter requires further consideration. As such, till the returnable status quo as on today should be maintained.
Yes, it's just that I got confused because I have seen these papers from the IA. Now, all the same pages are being referred from your affidavit.
For your lordship's convenience, I have.
It's all right.
So that the chronology is maintained.
Yes, yes.
Now, 28/10/2024, my lord had made it clear. Status quo as on today should be maintained.
Yes.
As on today means as on 28/10/2024.
Yes.
Now, what happens on the next day? If a lordship kindly turns to the next page, page 142.
Page
142, the next page.
Yes.
Kindly see at the bottom, my lord, it was Principal cum Chief Superintendent Nagaon. He writes to the applicant, to Messrs. Ranjit Borua. Kindly see the subject. Intimation regarding court order relating to maintaining status quo of dietary services for patients of Nagaon Medical College, Nagaon. Reference number so and so. Sir, in relation to the subject and reference letter above, this is to inform you that a court order dated 28/10/2024, case number WPC number 5479 of 2024, has been received by the undersigned to maintain status quo of the dietary service of the patients of Nagaon Medical College as of today, till the next returnable date that is fixed after 4 weeks. Therefore, the work order dated 21/10/2024 has been kept in abeyance till then.
Yes.
So it's an internal communication.
Yes.
This communication leaves room for no doubt that the order of status quo as on passed as on 28/10/2024 was within the knowledge of the applicant as well as the respondent authorities.
Yes.
And there's a clear admission. If your lordship kindly takes up page 15 of the IA for a moment. page 15 of the IA. It's a statement made on oath by the applicant, my lord. The fifth line rather.
Yes.
However, on 29/10/2024, the opposite party number 5, that means the principal.
1 second.
Sorry,
Para
sorry.
21
My lord, para 20, my lord. Page 15, my lord.
on the top.
On the top, my lord. Fifth line from top, my lord.
However, yes.
However, on 29/10/2024, the opposite party number 5, by letter dated 29/10/2024, informed the applicant that in view of the status quo order dated so and so, the work order was kept in abeyance.
Yes.
So it's an admission which has been made on oath by the applicant that they were aware of the status quo order as far back as on 29/10/2024. Status quo order passed on 28/2024.
Yes.
Next day it was communicated,
Yes.
and it's an admission made on oath.
Yes.
Now, what happens on 110? Kindly come to page 143. They
Yes.
knew there's a status quo order on 28/10/2000.
That agreement was executed.
Exactly. Kindly come to page 144.
1/11/24. Yes.
1/11/2024 at page 144.
Yes.
It's a surreptitious agreement
Yes.
entered by the applicant as well as the respondent authorities in collusion with each other.
Yes.
Kindly
Okay.
see page 144.
Yes, I've seen. Yes.
This contract agreement is made on
It's all right. I've understood. Yes. Yes.
once a judicial order is passed, it might be a good order, bad order, or an ugly order. The only remedy is an
Let's
appeal.
go back once again to that order.
Kindly come to page 138, my lord. Honorable Justice.
No, this code doesn't. You simply say this coordinate page. Why to refer
It's a
to
coordinate
the
page.
name so much? In the IA that order was there. No, at what page?
Your lordship.
The order of which the vacation is sought, modification is sought for.
That order, my lord, will find at page 151. 151. Well, I was coming to that order.
Yes.
I wanted to go chronologically.
No, just 1 second. I just want to see something.
Page 151.
It is better to 151.
Yeah, that order against which vacation is sought. It starts at 150.
Of the IA.
I didn't get your lordship's question.
Of the IA.
No, of my.
No, in the IA also it is there,
Yes,
no?
it's there.
You see, otherwise it gets confusing, Mr. Barwa, because this is not something I'm going to reserve for judgment and write it after. I have to give it right away. So if you same annexures you refer from here and there, I will mark something in your favor there. Now when I'm going to dictate the judgment, you want me to read what? So refer the same pages which the other sides have also made this code read yesterday.
Your lordship will
I appreciate that for your sake, for your chronology sake, you have annexed them once again. But kindly refer to the ones which are part of the IA. It's easier for the code. Because I can't be referring to the same document in two different.
Yes.
Yes.
Page 28, my lord.
Page
28.
28,
my lord.
28. Yes.
28.
Now you see,
what I wanted to.
1 second.
Right.
All right. Now take me back because I lost that page again. You just showed me the agreement.
Yes.
Where is that agreement?
That agreement, my lord, will find. That agreement is, my lord, at page number.
Okay, 69 also it is there.
One.
All right, I got it. 69 of the main.
One. Yes.
I'm taking it from here because I've marked in these
my lord,
pages yesterday. You see,
as your lordship pleases.
It becomes difficult. You tell me how the code is going to look into the same thing from 2 or 3 different places.
That's.
This is not the only case this court has to
Lordship-
hear and decide today.
Your lordship.
So many, and you see, I have already given a lot of orders prior to this, right? Now, our job just doesn't end here.
Yes.
It only starts when we go back. And you will not believe it, till 8 o'clock, 8:30, we have to sit there. And even after we go, the stenographers still can't go home. You know why?
Yes.
Because then they have to upload them in the system.
Perhaps
by the time they reach home, perhaps it is beyond 9.
perhaps your lordship has heard recently, Honorable
Only one page lost we have to record. Lordship is referring to the agreement and the sign dated and all. Lordship will start that from page 67. Then the Lordship will clear everything Lordship, at page 67. Because the process is started on 23/10/24. Lordship will take note of that. All these things are here. Lordship.
All right, Mr. Sharma, let me hear him first. You will have a right to reply. Yes. Mr. Barwa?
My lord.
First 11 you are showing from the agreement here. Yes.
Yes.
Anything more you want to show
Now,
from this
what I
agreement?
wanted to say,
Yes.
what had happened on 4/4/2025, the order against which a stay vacation has been filed on 17/9/2025, your lordship will see at page, your lordship wants to read that order from the IM on page 28.
I've read it. I've read it.
Yes. Now, kindly come to page 29.
Yes.
Your lordship knows the applicant was aware of this pending writ proceeding.
Hmm.
So, my lord, propriety demanded that on 4/4, when the matter was listed, they should have come and they should have said, sorry, although there was a status quo order, we apologize. We had, in violation of that order, we had entered into an agreement and that was a bad agreement and we should not have executed that agreement, despite the fact that the previous order dated 28/10/2024 was well within our knowledge, but they don't. They don't come to the court. It was within their knowledge. They don't enter appearance. We didn't.
They means?
They means the applicant. Who else, my lord? On 28/10.
No, I don't know who else. You are saying they. So I'm just trying to understand who are you referring as they? It's either the applicant so and so or the response so and so. So I don't know who they. So and please, counsels, do not question the court.
No,
you're not supposed to
I'm not questioning.
ask a question to the court. Yes,
I'm putting that question to myself.
That is there is a way of doing it. Yes.
Now, both the applicant as well the authorities should have on that day pointed out that despite there was a status quo order as far back as on 28/10/2024, we had entered into an agreement on 1/11/2024. So they did not. And they waited and they waited. They watched the proceedings from the sideline and they filed this IA on 17/9/2025 and they press urgency. So these are the facts before your lordship, undisputed facts, and the undisputed facts leaves room for no doubt that the applicant in the present case has not approached this honorable court with clean hands. Admittedly, the order dated 20/10/2024, which granted
was in their knowledge.
Was within their knowledge and they've played with that court's order.
All right, I have noted. Anything more?
And if your lordship kindly takes up the, my lord. Both the part, neither the applicant, we did not know.
You have said it, I've taken a note. Yes.
If your lordship kindly refers to section 2B.
Yes.
Section 2B defines civil contempt, my lord.
Yes.
It says, civil contempt means willful disobedience to any judgment, decree, direction, order, writ, or other process of a court, or willful breach of an undertaking given to a court.
All right, I'll deal with that. Yes. Anything more?
So these are the things. And the last limb of my argument is that if your lordship interferes with the order dated 4/4/2025, what would happen is that the connected writ petition would become infructuous. And this in turn would actually affect the patients. Because, my lord, when your lordship decides, your lordship only decides keeping the focal point as the public interest. That is the focal point. Your lordship will neither look it through my point of view or the applicant, because ultimately these are
Did you
business.
read yesterday's order?
That was not uploaded in the.
It is upload Quran Assembly order.
I tried to search. I could not.
I'll read one sentence for your
My lord.
benefit,
My lord.
Mr. Barua.
My lord.
In view of the public interest involved vis-a-vis the interest of the private parties, it is made clear that in the event objection as prayed for is not filed by the next date of listing, the application shall be proceeded in accordance with law. This court is aware that this is not just the private interest of the parties that this court is hearing.
Exactly. Your lordship is aware. And
Yes.
and a similar matter, my lord. Kindly come to page 159. There also a low bidder was page
Yes.
159,
Yes.
paragraph 15, only the operative portion.
Paragraph
15,
Yes. No, page
page 159.
159.
In fact, it starts at 152.
Yes, I got it.
I
In
myself had argued this
Indira
matter.
Enterprise.
I myself had
Yes.
argued this matter.
Which is the relevant portion?
Paragraph 15, page 159.
159.
159.
All right. Yes.
Now, page 159, it says, besides the above, this court is of the opinion that the basic reason for outsourcing food supply to the patient is to provide good, healthy, and nutritious food for the recovery of patients. Therefore, the prime consideration is to provide quality and nutritious food to the patients. The financial burden is deprioritized, keeping the health of the patients at the focal point.
Okay.
And accordingly, in that case, my lord, although the lowest bidder had quoted an abnormally low rate, they had not given the work order to that L1. Similarly, in my case, my lord, it is my specific case before your lordship that the rate quoted by the applicant is too low, admittedly too low. There are two court orders where the submissions of the department were recorded that at that rate it is
They
impossible.
cannot give
impossible
good
to
food.
provide, my lord, nutritious
food.
So suddenly through negotiation you cannot, my lord. So because ultimately public interest is what
All
matters.
right. Noted. Yes, Mr. Bora.
Sorry to interrupt. It was actually, my lord, the term used is predatory pricing.
Yes.
My lord, regarding the price, because in the earlier round of litigation, that was the issue before that, before the honor.
Now, just tell me two things.
Yes, madam.
Number one, what happened in the negotiation for which then after have they increased the price or something? What has happened after the negotiation? Because this court had directed a negotiation, right?
Yes, my lord.
So based on that negotiation, you have awarded it to the respondent number 5. But what happened in that negotiation?
Because in the negotiation, the applicant herein assured that with that rate, my lord, they can supply the good food, my lord, nutritious food. That was the negotiation, and that was the issue before this honorable court in the earlier round of litigation.
No, that is that the issue was not because
Yes, my
of
lord.
the court. The issue was because you had raised concern.
Yes, my lord.
Your officers had raised the concern
Yes,
that your rate is
Yes,
less.
Yes, my lord.
Whether you can provide nutritious
There was a
food. And ultimately this court said that you negotiate
Yes, my lord.
and they were ready.
During negotiation, they assured that with that rate, my lord, they will be able to provide the.
Okay, and thereafter, it appears that on the last date on which the date on which the order has been issued, not to finalize, it appears otherwise it was finalized prior to that date.
Yes.
Only formalities were there which had taken place later on. I think that agreement got signed after the date of the order.
Actually, my lord, agreement was signed prior to that, my lord. And the effect of the date was actually 111, my lord.
That is from
Because,
page
my lord,
27.
Yeah, because in the.
That is from page 67.
Yes,
You are
my lord.
saying it from 67.
It starts from actually page 66, my lord.
66.
Yes, my lord.
Yes.
Because in the page 66, it is a letter dated 21/10/2024. In relation to the tender number so and so, and being the L1 bidder for the stated tender and subsequent court order number so and so, you are requested to start the dietary services for patients of Nagaon Medical College from 1st of November 2024. You are requested to submit the signed contract in stamp paper for the same along with the security deposit. So, my lord,
Okay,
and
okay.
if your lordship peruses that agreement,
And the signed agreement, I think was 23/10/20.
2110, my lord.
21, sorry.
Yes, my
No, that page 67? Page 67, submission of
They have, yes, submitted, but
No, I am submitting here with my duly signed original. So this was done on 23/10.
10, and
So that is before the
yes, my lord.
before that
today.
passing of the interim, right? That's what I am saying.
Yes, my
So
lord.
with
And-
this, he must have given a copy of the original agreement, which is at page 68.
Yes, and
Because this
68
enclosure
was-
says, correct.
Yes.
So this date of 1 November that is given at 69 appears to have been given because of this letter dated 66.
Yes, my lord.
This is what you're saying, Mr.
Yes,
Gaur?
my lord. Yes, my lord. This agreement, which was signed on 21/10/2024, my lord, that was submitted to
Now,
the.
where do I get the date 21? Oh, it is here.
Yes, my lord.
At page 68.
Yes, all in all the pages, my lord.
21/10/24.
Yes, my lord.
Giving effect from 1/11.
11. And obviously because of that, my lord, that date has been put as.
Okay,
1/11.
understood. Yes.
That is that thing.
Anything more?
No, my lord.
All right. Please take down. Heard Mr. S. Sarma, learned counsel appearing for the learned senior counsel, assisted by Mr. S.K. Deka, learned counsel appearing for the applicant stroke respondent number 5. Also heard Mr. D. Bora, learned standing counsel held, and Mr. A.K. Barwal, learned counsel appearing for the writ petitioner number 1 stroke opposite party. This matter was heard elaborately yesterday, I-25/9/2025. And upon hearing the learned counsel appearing for the petitioner, the said order was passed. Quote unquote, paragraph 2, paragraph 3, paragraph 4, paragraph 5, paragraph 6, paragraph 7. Thereafter, pursuant to the aforesaid opportunity given to the original writ petitioner number 1 stroke opposite party, as well as the Bora, learned standing so and so. So and so filed an affidavit in opposition today. Stop. Relevant paragraph of the said affidavit reads as under paragraph 3. পড়া একেবারে 13, 14 লাগে দি দিবা Mr. S. Sharma, learned senior counsel, submits that the agreement the enclosed documents that it is evident from the documents enclosed in the interlocutory application, particularly '67, right? That I will tell in your submission.
Yes.
Particularly the earlier thing, everything is there in that order, so it will become a part of it.
Start from 56, my lord.
One second. That I will say, Mr. Bora. 60, particularly annexure 17, the letter of the petitioner whereby he has submitted the required documents, i.e. the original agreement signed on 21/10/2024 and the security deposit pursuant to the letter of the respondent health on dated 4/10/2024. Stop. Per contra, MS Barwa submits that the perusal of the in addition to the so and so, after taking this quote elaborately through the documents enclosed in the affidavit in opposition filed today, submits that the applicant as well as the respondent health, knowing fully well that this court by order dated so and so has stated the finalization of the subject NIT, the subject the agreement in the tender process was signed on 1/11/2024 pursuant to the aforesaid order, which is in gross violation of the court's order. Stop. Mr. Bora, so and so, in reply to the aforesaid argument of Mr. Barwa, draws the attention of this court to page 66 of the 65 or 66? 66, right?
Yes,
No, 65 of the, first you say 65, 65 annexure 15, whereby the respondent health by letter dated 4/10/2024 directed the petitioner to submit bank guarantee in view of the work order issued on 21/10/24 and thereafter.
I think it is applicant lordship, not petition.
Sorry, a 65 to Nokoba, huh? 65 to Nokoba, by referring to the work order dated 21/10/2024 enclosed as annexure 16 in the interlocutory application in favor of the applicant stroke respondent number 5 and submits that it is clear from the aforesaid work order that the petitioner was that the applicant was requested to start the dietary services for patients of Nagaon Medical College from 1/11/2024. It appears from the aforesaid work order issued on 21/10/2024 that that prior to the passing of the interim order, the work order was the petitioner, the applicant was directed to start the dietary services for patients of Nagaon Medical College pursuant to the in connection with the tender work from 1/11/2024, after which on 23/10/2024 the petitioner by his letter submitted the signed copy of the agreement which was executed on 21/10/2024 as evident from annexure 18 enclosed as evident from annexure 18 enclosed to the IA. However, it appears that while passing the order on 4/4/2025, the aforesaid facts were not before this court, for which this court directed the authorities of the Nagaon Medical College and Hospital Nagaon to make alternative arrangements for supply of dietary articles to the inpatients in the said hospital, and further clarify that the respondent shall not finalize the NIT dated so and so till the next returnable date. In view of the said, interim order passed on 4/4/2025 is not extended thereafter, I stands disposed of. Writ petition, when do you want it? Give a date in the writ petition. Yes. Pleadings are complete in the writ petition.
Affidavit filed on behalf of the.
So, Mr. Sharma, how much time?
Immediately after the petition.
In the writ petition, you say, by Gutekini presence Didiba and health has filed?
Health is also not filed.
So yes, Mr. Barwa, yours also important, most
Yes, my lord,
important.
yes, my lord.
How much time?
After 3 weeks time, my lord.
Not, okay, because 2 weeks will go in
Yes, my
Puja.
lord.
3 weeks time to file affidavit, to file return, both parties. Prayer allowed, relist on such and such date, date after 3 weeks. Yes,
Like, I is allowed.
I is allowed, disposed of. Yes, sorry, Mr. Barwa.
As I
Yes.
mentioned, my lord, we can only trial base.
Otherwise also, he has done his part, my lord. He has run up to.
It's
the
all right,
contract
anyway.
period.
We
He
give
has
our best and
completed
we'll give grace.
All right.
After the order, Lordship, I do not want to disturb his client, Lordship. His client approached my client.
Anyway,
They don't disturb my.
it's all right.
We have not disturbed.
Of like.
Lovely.